Good morning, Mr. King.
All right, so we just heard the 911 call that Chris Caden had. Again, he was the boyfriend of the victim, Melissa Howard, in this case. We just heard his 911 call. I want to bring on really quick Andrew Cherkasky joining me here, former JAG Air Force attorney. I won't be upset that you weren't a real Army soldier, but that's okay. Let's talk about this 911 call really quick, Andrew, if we could. We heard testimony where he said that it was possibly a shooting. And now, to give our viewers an idea, the reason he said that, now, again, Melissa was stabbed in blunt force trauma. When you walk into a crime scene and you see all this blood, you really don't know what's going on. What say you, Andrew?
Well, what we have here is testimony, I think, through that 911 call that it was a murder. The idea that it was a guess that it was a gunshot or whether it was stabbing and in a great sense of trauma. So I don't think that's the sort of thing that anybody will hold against you, that you weren't sure that it was a gunshot versus a stabbing.
Yeah, absolutely. And I want to clarify, you know, I was just ribbing about you being Air Force, me being Army, but I do thank you for your service. Now, the thing about this case is this is a guy on the stand, Chris Cadenhead, who was actually having an affair with Melissa at the time of her death. He was married 12 years prior to even meeting Melissa, and he's not considered a suspect in this case. I was listening to his testimony. Some of the things he said could be okay from a timeline standpoint, but that's something I would question too. In 10 seconds, do you think investigators looked at him as well?
I'm sure they looked at him and they discounted him for whatever reasons we're going to start to understand as this case starts to unfold.
Yeah, absolutely. Again, Melissa Howard was killed back in 2006. You can hear Christopher, the boyfriend there, said he found the body. He called 911. He actually called his wife from a different phone and said, hey, I'm at my friend's house and I just found them dead, which I find very interesting. Again, this case has so many turns and twists. We'll have more of it on the other side of this break. Stay tuned to the Law and Crime Network. We'll be right back. All right, we've been listening to testimony from Chris Cadenhead. He was the boyfriend of Melissa Howard. Again, this case has so many twists and turns. The guy on trial is David Holbrook. He was not even having an affair with Melissa at the time. He was just a friend of her ex-husband. And this guy, you heard testimony from Chris Cadenhead. He actually called his wife when he found Melissa's body, who he was having an affair with, and that's when she found out about the affair. Andrew, I want to touch on the defense and his line of questioning here, because it's quite clear what he was doing. And, you know, me as an investigator, I'd be doing the same thing as well. He's poking at his timeline. So he leaves UPS around 8:25, 8:30. He arrives around 9:15. And the only person that can vouch for his whereabouts would be his wife, who didn't even know at the time he was having an affair. And he just happens, and he even testified to, yeah, I usually don't go there. I was going to go to this hunting camp with my father-in-law and a few other friends, but he just happens to go to the murder scene, and he happens to be the guy that calls 911. It just, to me, doesn't look good.
Oh, Vincent, you're absolutely right. I mean, when you're on the defense side and you're trying to show that your guy didn't do it, that it must have been someone else, you got to try to find someone who has the opportunity and potentially the motive to do it. And so you saw cross-examination there that was actually very calm and deliberate. I think I would have been a bit more animated under those circumstances at really getting at this guy, but you saw him laying out the idea that there was opportunity, that he went out of his way to go to this place that he doesn't typically go at that time. He's got the motive potentially. His wife doesn't know that he's having an affair. Right. Is this something that where there's trouble brewing? And then the defense even squared into the idea that there's not a particularly good alibi. Who were you supposed to be hunting with? Right. And the witness is saying, well, my father-in-law, and there would have been some other guys, but I don't know who it was, essentially. So this is riveting stuff from the defense.
Yeah, absolutely. And I'm glad you mentioned motive, because we heard during opening statements, like, they don't even know what a motive that Holbrook would have had in this case. Again, he was not in a sexual relationship with the victim. He was friends of her ex-husband. And I want to read a quote from one of the investigators from the initial time of the murder. It said, "We didn't get anything back that's going to allow us to connect this to anyone." And they also said that they believe maybe this was a professional hitman. Now, I can tell you right now, it doesn't look like David Holbrook is a professional hitman. So really, if you think about it, if you're trying to plant reasonable doubt in a juror's mind, I think the defense may have a chance of doing that. What say you?
Well, that's what we have right now. I mean, that was a very compelling cross-examination, but the 911 call was genuine in its own right. So I think we've got two competing sides here with this witness. The government says that they're going to come with some forensic evidence and evidence that really starts to connect things that it took them a long time to uncover and that science was able to develop as time went by. So I'm very curious to see how that testimony comes out. This is good for the defense. You've got another guy who had the opportunity and potentially the motive.
Yeah, absolutely. Again, Melissa Howard was killed back in 2006. She was a mother of 3. On trial, David Holbrook, prosecution says he is behind that killing. We'll leave that up to a jury to decide, and if that prosecution could present that case. We're going to take a quick break. Have so much more to come on this trial. We're also covering Charles Merritt out in California. Stay tuned to the Law and Crime Network. We'll be right back. Hey, welcome back to the Law and Crime Network. Continuing coverage of the Charles Merritt murder trial in California. And with that, let's look at a very special report from our very own Aaron Keller.
How does this family of 4 disappear off the face of the earth?
California small business owner Joseph McStay and his entire family disappeared February 4th, 2010. Their car was abandoned near the border. Authorities believed this video showed them fleeing to Mexico, presumably to avoid business debts. Case closed? Not even close. Fast forward more than 3 years to November 2013. A biker discovered the skull of one of the family members in the Mojave Desert.
I was traveling on a dirt road. I stumbled across the remains.
All 4 were buried nearby. Authorities arrested Chase Merritt, a business associate to Joseph McStay. They believe he killed for money.
The why boils down to greed and greed's child, fraud.
The defense says Merritt didn't do it.
Charles Merritt, which everybody calls Chase, that was his best friend.
The state has presented appeared, but Merritt never cashed it. He told police there was always money and merchandise moving back and forth between him and McStay, since they frequently did business together.
Someone calls you that indicates that they are Joseph McStay.
Someone with at least some access to McStay's business accounts tried to change his QuickBooks software right after McStay vanished. The state also presented cell phone searches for information about the family's disappearance made by Merritt shortly after the family's bodies turned up in the desert. In those graves, a hammer prosecutors believe was the murder weapon. Also, shards of a bath mat. Authorities think it matches linens missing from the family's home.
They were beaten about the head and face until they died.
The family's home, prosecutors say, is the crime scene, but evidence is scant.
You will look for things, signs of violence, correct?
Yes.
And you didn't see any of them?
No, sir.
One officer who took photographs there realized back at the lab that she may have found blood on the family's table, but she didn't see it when she was in the house, and it was cleaned before anyone knew it was there.
When I saw it, I was horrified.
Why?
Because I thought it was something I missed.
The defense is pointing to an alternate suspect who also did business with the family and to unknown DNA found in the family's graves. This is Aaron Keller reporting for the Law and Crime Network.
Aaron, still with me, of course, Andrew Cherkasky and Brandon Birmingham, district judge in Texas. Thank you so much, Judge, for joining us this afternoon. I'll start with you, Judge. Let's talk about these QuickBooks. We heard the allegations that Merritt was stealing money from the business, writing checks to himself. We all get that. I don't know if that's yet to be proven 100%, but is that in itself a motive for murder, not only of Joseph, who he owed this money to, but his wife and 2 children as well?
Well, that's a very interesting point, and that's one that I've been waiting as I've been watching this trial to see how the motive expressed in the killing should match that. The motive that was expressed in the killing was perhaps sexual assault, the conclusion you might be able to draw from the clothes. But then you have the killing of the children as well. And I mean, in other words, the motive at the crime scene doesn't appear to be the motive that is being offered from QuickBooks. I mean, this was a very violent death for a lot of folks, far exceeding anything from QuickBooks.
Yeah, absolutely. Andrew, what say you about this QuickBooks and how it relates to the murders and, as the judge said, this alleged rape of Summer McStay? Is that enough? Because you would think that the anger would be directed, or the murder would be directed at Joseph, because that's who Charles owed this money to.
That's right, Vincent, and good afternoon, Judge. I agree completely. It's what I've been saying from the beginning, is the amount of money here doesn't seem to be particularly consistent with the degree of the crime that's committed. And that's not necessary, but it certainly is the idea that juries look for motives to match what the evidence tends to unfold. And so where we're talking about tens of thousands of dollars, but yet somebody's willing to execute a family, that type of money doesn't seem to be in concert with the degree of the crime here.
Right, absolutely. And speaking of these QuickBooks, let's actually hear from Michael West, who's a special investigator with Intuit. Let's take a listen.
Do you recognize that?
I do.
And is this check actually reflected on the activity log that you have as well?
Yes, it is.
And so this is a check that's created on February 1st of 2010, is that correct?
Yes.
And what time is that check deleted?
It is deleted at 12:47 p.m.
And that's reflected on your activity log?
Yes, and the activity log also shows the check number that was assigned to that check of 4092.
And who is that check to?
Charles Merritt.
Showing you what's been marked as Exhibit 427. Is this audit history reflected on the activity log?
Yes, shows a check was added at 11:27 on February 2nd.
All right, so that was testimony from Michael West. He's a special investigator for Intuit. He was talking about these QuickBooks and these checks made out to Charles Merritt. Judge, I want to start with you on this question here. Unless we can actually prove that it came from QuickBooks, came from Charles Merritt's phone number, but we don't know the relationship. We don't know the working details of what Joseph and Charles Merritt said they could do or he could do. So we don't know that yet. So do we actually have, something to say he's actually committed a crime at this point?
Well, I think you've got to be looking at all of the circumstances taken together. Certainly their business practice and who had access to the funds and who was allowed to draw money out. I mean, every business does it a little bit differently. I think where the prosecution is probably going to go, focusing so much on this stuff, is that maybe he was exceeding his authority to write the checks to himself. There was some talk before about how the accounts were different. One of them was in capital letters, one of them was in not in capital letters, which might indicate why is there a change unless there was something nefarious going on. So those are the types of little pieces of circumstantial evidence that the prosecutors are going to use to build that lack of consent.
Yeah, absolutely. And you made a good point about the capitals versus non-caps. Of course, people don't change their writing styles too much. Just like if you send a text, some people text actual words. More younger people text shorthand. So, yeah, that's something you can definitely look into as well. Andrew, let me ask this, though. The defense, of course, came back with a bombshell. Another business partner, Dan Cavanaugh, who there's an email chain between he and Joseph McStay where it was pretty heated, and he actually told someone that he knows how to bury bodies in the desert. So how do we get to Charles Merritt being the only person, and I want to emphasize that, the only person on trial for killing 4 people single-handedly?
Well, the judge has been very limiting in what information is allowed to come out about those messages from the business partner, and that's troubling. But what the defense can do is expose the idea that there are other people out there that weren't adequately looked at. The defense has started from the very beginning to talk about this idea of confirmation bias, that it was the investigators who decided early on that it was Charles Merritt who was the suspect. They will have a huge door to open up for themselves, as they have already, to flesh out the idea that a number of other people could have done this, even if there is some evidence to establish that Charles Merritt was the one who had sufficient motive and opportunity to do this.
Right. Andrew, Judge, stick around with me. When we come back, we're going to jump right back into the Charles Merritt murder trial in California. Stay tuned to the Law&Crime Network. We'll be right back. All right, I still got my all-star panel with me, Andrew Cherkasky and Judge Brandon Birmingham. Judge, I want to ask you this really quick because we're listening to this testimony about DNA, and I'm sure there's a lot of people wondering why we're listening to this testimony, but I would assume it's to actually say, yes, we identified.
Last question again.
Yeah, so I assume that we're hearing this testimony about the DNA because you want to be able to say we identified the McStay family, that this was them found in these shallow graves through DNA, and that's why we're hearing this testimony about the DNA and how to identify an individual.
Yes, and this is a good way to do it. I mean, obviously, the law requires to prove that there was the killing of a human being. But really, more importantly for that, it's that we've got this crime scene. We're establishing the crime scene. We're establishing the identity of those victims. That is vital for the investigation because we need to know who the victims are, who might have had a motive against the victim, the manner in which they were killed in order to aid them. Investigation. So we've got a lot of for sure.
Yeah, and Andrew, let me ask this. Let me switch gears because we're talking about the DNA of the McStays, but one of the biggest things, we got about 30 seconds here, that there was no DNA found of Charles Merritt inside that home.
Well, this is the point that we're getting at. I mean, maybe that's why the prosecution's drawing this testimony out so long. It's just unnecessary at this point for them to be going on and on with it when the point of the matter is that there's not as much DNA as I think the prosecution really wants.
Andrew, hold that thought. We got to take a quick break. We'll have so much more to come and also an update out of Iowa on the other side of this break. Stay tuned to the Law&Crime Network. All right, it looks like that Charles Merritt courtroom is going on a quick 15-minute recess, or so they say, but we know how live trials go. 15 minutes can turn into an hour or two, just depending on the judge, the jury, and the attorneys getting back into that courtroom. So while I still have my all-star panel of esteemed gentlemen, let's bring them back on, Andrew Cherkasky and Judge Brandon Birmingham, and let's talk about this case. You know, I touched on this earlier. This has been a long, drawn-out case by the prosecution. Judge, I want to get your thoughts on that. I know you've probably sat through some very long trials. Do you think that affects the jury as this trial continues to drag out by the prosecution?
Yeah, you as the lawyer want to be very mindful of the jurors' time. You never want to lead on that you're not ready or that you're unmindful of their time. And also strategically, you want to keep reminding them. I used to, if I had longer trials, I would always try to go back to my main exhibits, keep reminding them about the main things that they're going to do. There's no way they're going to go back and remember, 90 days ago what happened, but they might remember a picture that you keep referring to or a report that you keep referring to. And so you've got to be very mindful of that.
Yeah, and Andrew, the judge brings up a great point. He's talking about a picture they may have seen 90 days ago. And keep in mind, the murders occurred 9 years ago. So not only is this a cold case, essentially, now you have this trial that's just going on and on and on. So there's a lot to try to keep in your memory as a juror.
Well, right. The defense counsel and the prosecution both have a very difficult task to keep the jury on point to what they think is most important. Mm-hmm. Now, today we're seeing this long DNA testimony. I think that's the sort of thing that's a major mistake for the prosecution. They can put a DNA expert up, say, are you qualified as a DNA expert? Yes. What's your opinions here? The DNA expert does not need to go on for hours and hours and hours. That's the sort of thing that distracts them from the real evidence in this case, and it loses the juiciness of it.
Yeah, because essentially he's giving like a DNA block of instruction, and as a juror, I wouldn't want to hear that. I just want to know, listen, was that DNA that of the McStay family? Other than that, I could care less about what you have to say. Now, again, the prosecution has said this was about money, some QuickBooks that Charles Merritt may have written checks to himself out of the McStay business account. Let's take a listen to Michael West, who is a special investigator for Intuit.
Do you recognize that?
I do.
And is this check actually reflected on the activity log that you have as well?
Yes, it is.
And so this is a check that's created on February 1st of 2010, is that correct?
Yes.
And what time is that check deleted?
It is deleted at 12:47 p.m.
And that's reflected on your activity log?
Yes, and the activity log also shows the check number that was assigned to that check of 4092.
And who is that check to?
Charles Merritt.
Showing you what's been marked as Exhibit 427. Is this audit history reflected on the activity log?
Yes, shows a check was added at 11:27 on February 2nd.
Okay, so that was testimony from Michael West from Intuit. He testified about a check that was created and then deleted on February 1st of 2010. And why this is important, the McStay family went missing on February the 8th of 2010. And just prior to Joseph and his family going missing, there were some phone calls between Joseph and Charles Merritt, the defendant in this case. There were also phone calls from Joseph McStay to QuickBooks and to his bank. So I'm assuming it was about this check. Of course, that's what the prosecution said this is about. Let's listen to the defense opening statement in this case.
Then they say Merritt stole money from EIP after the family disappeared. They say he stole money. EIP is Earth Inspired Products. That's the acronym you'll hear referring to this company all the time. Checks were written on February 5th and backdated to the 4th. Well, they met on the 4th to talk about those two. And Joseph brought the blank checks to Chase to cover costs. We had forensic accountant Dennis Sjogren review all the financial records from the businesses, from Joseph, from Chase, and others. I'll cover the part he talks about this transaction. He said, in his experience of 20 years of tracing assets and seeing business valuations, he says all the monies received by Merritt after their disappearance would have been reasonable compensation and cost coverage to finish those jobs that were already in effect in February of 2010. Remember, they didn't get a financial accountant, so we did. That's what he told us. I'm sure my colleague will tell you what else he found. They had a practice of doing business with EIP and between him and Joseph. After handling something for Joseph, Merritt would always call him to update. So, he wrote 4 checks and deleted them at 12:39. Then he calls and leaves a message 10 minutes later. And it's done. Then he's on the phone with QuickBooks for 108 minutes on the 8th. This is when they want to switch from online to desktop QuickBooks. Why do you do that? Online QuickBooks you can access from anywhere, and anybody can if they have your password. If you want to keep your business information from people you don't trust anymore, you switch to a desktop. Nobody can access unless you're sitting at that desktop. So that's what Chase is doing on the 8th. He's on the phone for 107 minutes. The technician's saying, yes, you want to transfer all information from online to desktop, no problem. After you do that, then I want to get rid of and delete the online account so nobody can look at anything anymore. Because all the information is saved on desktop. When they interviewed this woman, she said, yeah, that's common. People do that all the time. Then when Chase calls back on the next day saying, hey, yeah, I'm trying to do all this stuff. It's a new technician, and their notes are, he just wants to delete. Well, did you not read the notes from the day before where it says he's transferring funds? It's done. Hey, buddy, I don't know where you are, but this is done. Call again on the 9th, finish that call. 29 minutes later, hey, by the way, I finished all that. It's done. Not hiding anything. It shows he's updating Joseph, telling him, I'm doing what you told me to do. Joseph would actually always call Merritt, too. It's a shared practice. The checks that they talk about being deleted, they were created and deleted at 12:47. Joseph called Merritt at 1:03 right after. Joseph created more checks on the 2nd at 11:37. Called Merritt 3 minutes later, let him know, hey, yeah, this works. We can do it. creates and deletes check on the 4th at 8:01. Last phone call at 8:28. Hey, it's done. That shows that Joseph's still alive when that car's leaving at 7:47. I don't know who was there. He's still alive, doing business. He's alive till the morning of the 5th.
All right, so that was the defense in the Charles Merritt murder trial, their opening statement. Still with me, my all-star panel, Andrew Cherkasky and Judge Brandon Birmingham. Judge, I know your time's coming to an end here. Let me toss this to you first. We heard testimony from this expert, this financial records expert, who said, listen, the payments received by Merritt after the family went missing, because it wasn't a murder trial at that point, were reasonable payments for him to finish that job. So again, if the prosecution is saying this is about money, but you have someone saying, hey, it's reasonable payments to finish jobs that were in work order status, then do we really have a motive to say this was all about money and that Charles Merritt really wasn't owed this money?
Yeah, I think you're seeing two competing dangers from both sides, really. If you are the prosecutor and you're putting up the motive in this case being QuickBooks and taking money, the defense is putting up forensic testimony, accounting testimony to say this was just normal practice, this was the normal course of business, this is how they conducted business, nothing unreasonable, well then that goes a long way to create reasonable doubts in the minds of jurors. That's the risk that any prosecutor runs when they're putting up a motive. On the other side of the aisle, you've got the defense who's going to be putting up an alternate theory, this Mr. Kavanaugh, Dan Kavanaugh, that he's the one who committed this crime. Well, if the jurors don't believe that, my experience is that when you put up alternate theories, it's almost like they're mutually exclusive. If you don't believe this one, well, maybe it really is that the defendant did it. And so there's a risk really on both sides, and we're seeing that play out in this trial.
Yeah, absolutely. Andrew, let me ask this, right? Even in 2010, we had the technology to track calls and to see who was calling in and logging in from computers. Do you think it would be really stupid of Charles Merritt, if he did do this crime versus he was allowed to do these transactions, to actually call QuickBooks or to log in from a computer and make some checks out to his name? I personally think that would be really stupid, because you have to know you're going to get caught. What say you?
Well, that's a fantastic point. I think one of the errors, though, that you might be kind of applying here is the idea that murderers think logically through everything. So it's not necessarily that he did do it or didn't do it in that way, but the idea that we're applying some sort of perfect logic. When people are engaged in murder or engaged in something that they've never done in their entire life, it is an adrenaline-filled experience and something that you see mistakes made along the way. The problem, though, is I think the judge is right. Trying to pick the side.
Andrew, stick with this. Judge, I know you have to go. Just so you know, it's only about 26 degrees here. I don't even care what the weather is in Dallas, Texas, but I do want to thank you for your time. We're going to take a quick break. We're going to have so much more to come in the Charles Merritt murder trial on the other side of this break. Stay tuned to the Law&Crime Network.